Hi, everybody. Good afternoon. It's glad to be back after a month. Today, we are going to have a good speaker who's going to share with you on the legal issues that we face in our daily practice as far as real estate is concerned. You know, over the last many months, this thought has gone through my mind. Is this real estate scoop with Soma really helping our practitioners out there? We are doing this because we feel that a lot of you may not be aware of a lot of things. So the learning process continues as far as our real estate profession is concerned. And so we do this to help our RENs, our REAs, although they may have all the experience, to share some new insights about what's happening in the real estate practice in this country. So generally, I know it's difficult to make comments. So if you have any comments, I will appreciate if you all can just put in a short line. You like it, you don't like it. Maybe there are certain topics that you have that we can talk about, and also are there any new things that we can do? Okay, so I'll appreciate that. If you have my number, you can WhatsApp to me at 012-2136-236, 012-2136-236. That is Soma. And then if not, you can always send to the, there is a, afterwards you will have the, to scan the code so that you will be able to give your feedback. Okay, so as usual, I've got some announcements to make. The first announcement is that RRP has started, Rent Renewal Program. It has started, and so reminder, every year there are hundreds of rents who fail to attend the class, and then what happens is they will have to come back and do the NCC again. Many of them. So let's not waste time. Let's not waste money. So we can do that. The second announcement I want to make is on ACE. I think that's a slide number 1. ACE convention. Okay, we are very happy. Arena. You know, we have had Arena convention. First was in Bangkok. And then we had it in KL, which was very successful. And then we went on to Cambodia, then we went on to Myanmar. All these conventions were very unique because we brought the entire ASEAN real estate practice together. And now there are many friends that you know in the other countries, and you can network, and whenever you travel, you can meet up with them. And the friendship and fellowship is growing. But when COVID came, it all stopped. Philippines was supposed to host the next convention. COVID came, and until last year, we couldn't do it because it was difficult to pick up the momentum. And so this year we said, no, we must start this back. So we had a meeting in Phuket, and a few months ago, and we decided that we need to do this. And so Cambodia has volunteered to start it off again, but this time it's not in Phnom Penh. It is in Siem Reap. Siem Reap, you know, is famous for Angkor Wat. Beautiful place to visit. Party place. I was there just a couple of days ago. I went and checked out the place, grand hotel, and I'm sure all of you are going to enjoy it. So the registration fee have not been decided, but we know for a fact that it's less than US 200 ringgit, less than US $200. And so I would suggest that all of you plan your dates. Is from the 29th to the 31st. 29th is where you're going to have the cocktail reception, 30th opening ceremony, and 31st you'll finish half a day, then you do your tour. So again, 29th to 31st of August this year in Siem Reap, Cambodia. Okay, so hope to see as many of you as possible. Okay, so now is the guests that you have invited. Today we have a very experienced lawyer. Can I cordially invite Mr. David Koch. David.
Hi, Mr. Soma.
Hi. Please take a seat.
Thank you.
Now, he's a very familiar face in the real estate sector. First of all, he has been a advisor for MIA, legal advisor for MIA for 16 years, huh?
I think about 16 years.
16 years, a long time to be an advisor for an association.
Yes, I don't know how I survive.
Especially among agents.
Among outlaw, they're okay.
Okay. David is a long time and has been a friend of ours for all these years. He has advised us in many capacity. Normally, he's always very busy at the AGM, which just concluded. He will be answering all the legal questions. So he has attained his LLB honors graduate of the University of London in 1992, managing the partner of Messrs. David Koch and Partners, 30 over years of legal experience. And then he's also written a few books. What books have you written?
I've written about 3 books.
Okay.
One is called Convincing Law and Practice Malaysia, and the other one is called Legal Guide to Convincing. I've written 2 editions on that. So this book actually is a little bit different. I thought, I'm not a professor, so I thought more of procedure, because when we lawyers or like agents later also, that's what we're trying to do.
Mm-hmm.
When as lawyers, when we practice, obviously we study the law. But when you work in a real world, a lot of them do not know the procedure.
Okay.
They don't even know how to start off with a letter and whatever.
Okay.
So what I did was I put down all these procedures inside
Okay.
these 2 books of mine. So right now, that's what we want to do for rents and estate agents also. You may know some law, you learn the standards and all that, but practical wise, how do you do it? So maybe that's the future plan.
That's the thing.
Yeah.
We know a little bit here and there, but
Yeah.
in real application, we
Real
don't know. And
application.
I think you're going to share some of these in
Yes.
the subject matter that we are going to talk about. Okay, so legal issues in real estate. We kick off. Okay.
Okay.
So the first question is, what are the most common legal claims that agents make or lawsuits filed by real estate agents, and how can we proactively avoid them so that we don't have a lot of cases because either we don't get paid or we do things wrongly? Just common ones that you face.
Common one. So usually the most problematic one is rents and agents tend to copy and paste a lot of things. Like your agreement to purchase, your appointment letter, and you'll not cater to the needs of each case, which can be different. So they do not write it down, and they presume the clients will agree to all these kind of things. So sometimes we have to avoid accordingly. Like for example, maybe you have stated the wrong facts to the client, and this will amount to some claims. And later we will talk about it also. Maybe you fail to disclose something relevant, then also give some problems. And but most importantly is they take a lot of time. They get in trouble is because they take certain facts and certain things for granted and not explain it to the client properly. I'll give you an example. Maybe a just simple example. There was one particular case we seen before where this agent, he rented this property to this tenant for a warehouse to do factory work. And then what happened was the tenant asked the agent to ask the landlord whether the height of the property, does it have 16 feet or not? Is it 16 feet? And then the agent actually went and asked the landlord, and the landlord said, yeah, I think about 16 feet. So, okay.
This is a factory.
It's a factory, a warehouse,
All right.
so there's a height. So he said, okay, we have 16 feet. And then what happened was then, at the point of time, I think nowadays the board have sort of discouraged it. The agents do their own tenancy agreement. So she took the literal word of the landlord and said there was 16 feet, drafted the tenancy agreement, never put this term inside. So later, they paid everything, deposit sum, everything they paid. When the tenants' truck come into the warehouse, it was like 14 feet plus, cannot go inside. So imagine the chain reaction. So lucky, she know both party, they managed to negotiate something out. But I was telling her, you are very lucky. Because they signed a tenancy for 3 years, right? Supposing if the landlord say, well, we agree on what we agreed as per the tenancy agreement, 3 years. And if you come out of it early, because it never said anything about 16 or 14 feet, you pay me the equivalent to 3 years of the rental.
Okay.
So they're just lucky they managed to negotiate it out and came out. So I'll give you an example.
So, okay, I want to stress one particular point in this question.
Yes.
About we don't get paid legal fees.
Okay.
How common is this?
Very common actually. And I feel that the mistake most agents do is because they don't protect themselves in black and white. Okay, the mindset of most agent and negotiator, I can't blame them. They were taught maybe the old school was either I have exclusive listing or nothing. That was the mindset. So of course, I think most of you all know what is exclusive. Exclusive means they appointed you exclusively to sell or rent the property. If you sell it for the principal, they have to pay you. Some other people sell it, they still have to pay you. Very good. So that one usually no problem because it's written in black and white. But a lot of them, when they did not get the exclusive, in their mind they are thinking, when I find the purchaser, I get them to sign the agreement of purchase, I take the money, then I run to the vendor to get them to sign it. Now, what happened when they go to the vendor said, well, I think I want to pay you only 1.5% or 1%. I don't agree to this, I don't agree to that. So how do you counter this? Because a lot of people do not know, maybe the terminology may not be so accurate, so someone can correct me. You can have something what you call somewhat like an ad hoc appointment. So the ad hoc appointment states, in your appointment letter states that, I'm not exclusive, but if I manage to sell a property for you and you accept my purchaser, my 1 to 10 terms which we have agreed, how much you paid me, who is to hold the money, etc., it's already pre-agreed. So no need to negotiate. And then you come inside and then less headache because everything already pre-negotiated as long as you accept my purchaser. So that's actually
if I may just add on it, the problem exists because many of the agents, negotiators think that you're right, we do it later, but when they do it later, but the problem is they should actually do it from day one.
Exactly.
If you don't get exclusive, you got non-exclusive, open listing. Anybody can just get the appointment letter. Especially the fees must be confirmed. So if you don't do that, then you have these kind of issues.
In fact, why it's also good to do this so-called ad hoc appointment? Because in this appointment letter, it also protects the agent and the rent. For example, it authorizes you to put advertisement or advertising or banner on that property. So you don't have issue, you see? You ad hoc, you simply hang there, hang here, then later only people say, I didn't appoint you also, So all these things is pre-appointed, but I'm not exclusive. I'm not exclusive, right? I'm ad hoc, right? No problem. But you have agreed to these terms, right? You allow me to put advertisement, to sell or whatnot. But later when you accept my purchaser, then the terms you have agreed, who is to pay for SST, how much is my fee, who is to hold my earnest deposit, whether it's the agency, the vendor solicitor, etc., whatever you pay upon.
So this is interesting. You just brought another point. SST. You collect your fees, but SST, you cannot collect. So in fact, now I am actually proposing to a lot of rents, when you go and do the listing, don't collect 3%. Tell the owner, can I collect 6%? 4% as deposit. Because when you collect 4% deposit, you deduct your 3% fee and then you deduct your service tax, then you pay the balance. Provided you make sure that the owner agrees to pay, requests to pay deposit as 4%, not 3%. Wouldn't that be a good idea?
It would be a good idea. Of course, you get more money in hand is always a good idea, right? But of course, at least the SST amount. And what more nowadays, as you know, coming in the big way, e-invoicing. So e-invoicing, all these issues will be coming in already. So you have to do it more.
Okay, let's move on to the next question. Many a times I've always mentioned this in NCC and also to the rents. Everything we do, or almost everything we do, has got to do with law. You sign a contract, it's a law. You go and make representation, it's law. So I always believe that contract law is important. But young agents these days, they don't care. They just say the things they want to say, not knowing what the contract laws stipulates, how we should live within that the rulings. What do you have to say to all those out there? Is contract law important?
Of course, very important. If not, lawyers also got no job, right? And why it's important is because how contract law help you. You know, whatever appointment letter, agreement to purchase, or whatever letter that you do, actually can protect the interests of all party concerned, the purchaser, the vendor, and even the agents. You see? So if you do it properly, then everybody know, number one, what they are supposed to do. Number two, what are they entitled to? And then when are they entitled to these things? This is I'll give you an example. Sometimes when you don't do it in black and white, we take many things for granted. So just now I told you we got appointment letter, for example. So I appoint you to sell, all right? And then in the letter, they agree if you sell, right? They pay you, say, 3% of fees from the sale price, right? Then who is to pay for the SSD? Then come the next few questions, which sometimes not covered in all the letters. Number one, who is to hold the earnest deposit? Is it the agency? Is it the vendor? Is it the vendor solicitor? Okay. Number two, okay. When I manage to close the deal, can I contra the fee, my fees, from the earnest deposit? When can I get the fees? Upon the execution of the sale and purchase agreement, upon the state authority consent being approved, upon the bank loan being approved, upon the vendor doing something, repairing something or whatever. So when? So actually, there's a lot of things down there. It looks simple, but actually, we have seen many cases before. When it comes to the crunch, you go to court, the 1 word, 2 word can kill you. All right. So these kind of things are essential. That's why contract law is very important. That's why I always advocate in contract. A contract can bind people. It can be made by way of written, something written, and also oral, something you say. But the first rule of thumb, I tell you, put everything in writing. Oral, your word, my word.
Don't trust anybody.
Yes, don't trust anybody, not even your own family members. So that's it. We have seen many cases. Okay? Yeah.
So, okay. So, how do you? What do you suggest to those out there? You cannot become a lawyer, lah. What aspects of the contract law should you at least have a basic understanding?
Okay, I think the most important. I teach this in all the RAN class in NCC. For a contract to be valid, there must be only 4 things. There must be an offer, acceptance, intention to create legal relation, and consideration. So money also very important. So sometimes some of the problems the agent have is vendor sign the letter of offer, purchaser sign, check given, purchaser said bank in 3 days later. So now my question is, you should tell the purchaser, your money better, faster, clear, because if tomorrow the vendor want to sell to another, your transaction no consideration, this LO is not binding at this moment of time, because there's no consideration. So if any one of these 4 elements is missing, there is no contract in law. If you study contract law, you just need this 4 perkara lah, right? So what I'm trying to say is your 2 sheets of paper is very important in real estate agency. Half the cases that go to court or go to the board is because of the 2 sheets of paper.
Yeah. That goes to the next question. I call it the agreement to purchase, letter of agreement to purchase. Okay. So in the agreement to purchase, sometimes most of the time when it comes to sale, there's always a compensation for the seller if the case is aborted. He forfeits the money and then he shares 50-50 with the agency. But what happens in a case where the seller himself aborts the case and there's no clause on compensation? What happens then?
then you got a problem. Now, some agency, they actually have a clause. They are put there. If it's the seller's fault, right? Let's say that the vendor for some reason did not complete the transaction, then of course he have to return all the money, and he have to pay a sum, usually in practice, equivalent to that amount. Since he paid the purchaser, will be shared between the real estate agent and the purchaser.
Or that money is to be shared between the estate agent and the purchaser. Okay.
That's right. That's why it's good sometimes all pay back to the agency.
But there's no such clause in any of the ATPs where if the compensation is by the vendor to the buyer, that fee can be shared with the agent. It's only in the case of the buyer, seller, when he forfeits.
That's why I must always emphasize that in the class I tell you, even the standards, they have a standard, so to say, agreement to purchase an appointment letter. But this is something like a contract. So it is never standardized. You can modify accordingly. And I must say, there are some agencies who actually have these clauses.
Okay.
So they do lah. They move with the times.
It's very rare. Very few organizations do that.
Maybe you should.
So one of the things that when David and I was discussing this earlier is that agencies today also need to change with time. You are all doing agreement to purchase that was drafted, I think, probably 20 years ago. 20 years ago, or maybe 10 years ago. You need to change because you need to put the compensation for the buyer in the event the seller aborts, and then the fee that you have to share when the compensation is paid. So probably we need to change the agreement to purchase. Okay. Next question, David. I'm always excited about this concept about principal-agent relationship in the context of the Contracts Act. Okay, principal-agent relationship.
Okay.
Why I'm emphasizing this is many of the agents do not realize their responsibility and role when the principal or this is in the context of the vendor and myself as the agent. What is our role and responsibility when you are appointed as an agent?
Okay. When you are appointed as agent in general, the principal is the person that appoints you to do something for them, to sell or rent the place for him. So your job is to do this task that he give to you in accordance to the authorization, the scope of authorization given to you, and nothing else, right? So that means you sell at this price, you can advertise, you can negotiate or rent or whatnot. So if my advice is, if the principal asks you to do something over and above, and you need to do something else, or maybe the purchaser tells you, I want you to repair the gate first before I buy. And you presume, you talk to the vendor, Mr. Vendor, the purchaser have requested this. Do you agree? And he tells you already, I agree. Then you spend your money, you thought you can claim back. Later say, no, I never really agree to this. Where's my black and white? Then the whole problem comes because you jump the gun. So if you want to do something over and extra, I suggest you better get further authorization before you do it and not out of the scope. So a lot of people are going on a presumption. Of course, there's a bit of a common law practice. The board is very experienced. If they find that the way you deal with the transaction is a normal, customary way, which another agent or rent deal with that kind of transaction, in that manner and method, they may accept, but it's a very gray area. And the stance of the board nowadays, I don't speak for them, right? But from what I see, sometimes I have some cases with them, they prefer black and white. I cannot blame them. We don't want to guess. So you go to court also, say we are supposed to guess. So we don't want. Not that we are speaking for the board.
So in the same context, you said there must be an authorization. You need to follow the instructions laid out in the appointment letter. What happens when a rent advertises a property for 400,000 when the owner asks to sell at 500 or let's say 450, and you think, I put 450, I'll get an attract buyer. What are the legal implications of this?
I think if this has been discussed with the owner, okay lah, if it's a purely a tactical reason, for some reason.
Authorization is 500.
Yes.
Now you go,
Yes.
you
So if, aside end of the day, even if the rent sell at 450, it's still up to the principal to accept or not. You see, because you're not supposed to because he wants a minimum of 500. But you also have to be very careful. Because sometimes you think this is tactical because you think you cannot sell at 500. But by doing this, the vendor or principal may turn around and say, you know, by doing this method of yours, it costs the entire market for this area to drop. Hard for me to sell. Because you're giving the impression, if they take the what do you call
the competitive
competition. Oh, everybody is selling at around 450, so I cannot sell at 500.
But isn't that rent exceeding the authority when the vendor himself said you are supposed to sell at 500? Let's say he never told us to advertise. Isn't he exceeding his authority?
Yeah, he may have exceeded unless he's very smart. He put a clause down there, said to sell at 500,000 or any other sum agreed upon by the principal. Or in writing.
All right.
So
Okay.
you cover yourself.
Okay. Okay. This goes back to many of the things that you talked about. Is getting an appointment letter signed important? This is so basic. I wanted to address this in this scoop.
To me, it's very important because half the time, even right now, this week, we are having. I am being approached by agents or companies where the people are not paying them. You know, the appointment letter is either not strong enough or they don't even have appointment letter. As I said, I think there's also a misconception. They think exclusive or nothing. But actually, you can have an ad hoc appointment. So that also will cover this thing. And another thing I like to stress, maybe it's a mindset thing. This is only my opinion, all right? I had many arguments with litigation counsels, my friend. I did some litigation in old times. You know the earnest deposit you hold?
Yeah.
Some of you all call it stakeholder. But actually, in our opinion, it shouldn't be called stakeholder. Because stakeholder definition is like, for us lawyers, we hold something where we have no interest in it and waiting for outcome or something. So like for example, we take the balance purchase price, we hold it to do apportionment of outgoings and see any late payment interest, who is to pay what, vendor and purchaser. We work out the thing, then we give to them. We lawyers don't take money from it. So the issue is why you all have so many cases in court. Because of the earnest deposit sum, you lump your fees in it, you're having an interest in it, number one. And number two, the money is paid by purchaser. So if vendor fault, some of the agent trying to claim the money from this earnest deposit, but whose money is that? That's purchaser. You don't act for the purchaser, you act for the vendor. Vendor is supposed to pay you the fees. So what I'm suggesting to the whole industry is the fees should be paid separately from the earnest deposit sum, like lawyers do. So lawyers, we hold deposit sum, we don't really contra fees from there. Is it? Fee is fee, stakeholder money is stakeholder money. That is why we have less problem, is it? Because you also fight your fee inside there. So like it or not, when you're holding all this money as so-called stakeholder, when there is a dispute between the purchaser and the vendor, this is a problem in this industry, very hard to solve. And then both sides want their money back. The vendor want to forfeit the money, the purchaser want the money back because he thinks the vendor's fault, and you are the agent holding. So both sides writes to you and say, please give me back the money. Then you're thinking, I give to vendor, I get sued. I give to purchaser, I get sued. So I don't give. Don't give, they report you bought. Then they also start suing. So when they take an action against each other, like it or not, just say the vendor take action against purchaser, they will drag the agent in also. Vice versa, when the purchaser take action against the vendor, you're dragging the agent also because the agent also holding the money. So many times we have to come out for real estate agency and explain to the court and tell them like, look, it's not that we don't want to give back the money, we don't know who you want to give to. So if the court make a decision, who is the winner or whoever's entitled, we give. Then, but they have to spend money to do this. So this is we feel it's the biggest problem in the industry.
You have just opened up a big can of worms. Yeah. I remembered in our days when 87, when I started my career, all this was so not written in any document. Yeah. And so lawyers and the vendors themselves were the one who hold the money. And then after we finish our work, you are going back. Yeah. And then, compared to the legal fraternity or medical or estate agency practice is still very young, and so the maturity among the public that you are supposed to be entitled for it is not still strong in their mind yet. So then slowly what we did over the years, that's what we did, we collected. But I think the point that I want to accentuate from what you said is, when you collect the money, you must understand that that money is not yours. Yeah. So correct me if I'm wrong. When the buyer pays the deposit, the money belongs to the buyer. Yes. Right? We're holding on behalf of the buyer. When the offer is accepted, then the money now belongs to the seller because he's already accepted the offer, the consideration. Then when there's a dispute that happens, of course we still hold it. Then either the court or they have to come to a compromise to settle it. Yeah. Then the money will be dispersed, and we cannot participate in it. So whatever fees they're going to deduct, you need to treat it separately and not. But again, our maturity is very important. How we treat the money that you're holding on behalf.
I think for me it's a simple solution, but we need the help of the people in charge, the board or whatever, to just come up with a ruling with the standards and says that you cannot take the fees from the earner's deposit, and fees should be collected separately. And then tell the whole public that the e-invoicing coming now, e-invoice them, that's my fee. I done my job, pay me my fee. So in that way, indirectly also you got an appointment letter. So in that way also you secure your fees, because if anything, because of this relationship, you can sue them for your fees.
There will be a lot of legal suits.
But after a while, you see, it's like this is like labor pain, right? After a while, people realize when you have more cases and then all this go through already, then the public realize, if I sue you, you're going to lose. Because we already have precedent on this.
Okay.
I feel
my personal view, maybe we are not ready yet. It's a good legal point, but I think the public and also the agents are not ready yet. Okay, never mind. I think that let's put that in our mind, and maybe we can discuss and see what we can do. Okay. Okay. When vendors, I asked this question. We discussed about this already. What can we do when there is no clause? I think we did that, right? ATP for compensation to buyers. I think you already mentioned that, sorry. And then what are the legal obligations for disclosures in a sale, and what risks do agents face if a seller or agent withholds information?
Okay, so this one,
give some examples.
We have to dissect it carefully, right? Some people, they sell the property, they tell them, as is, where is, whatever condition, right? You inspect yourself, right?
What is as is?
That's right. I'm going to explain this again. So some people got a misconception. As is, where is means the day you inspected it, as per that condition, or you signed the agreement that day, and later at the end of the transaction, the condition must be substantially in the same state and condition from the time you inspected it. Fair, wear and tear accepted. Okay, you shave, you take out a nail, small hole, okay, fair enough. If something bigger, you have to replace it. So for example, when you buy a property, there's a hole in the wall, right? So you say, never mind, I accept it. So at the transaction, the hole in the wall there, no problem. But later, you found another hole in the wall. Now, the first hole I accepted,
The new hole.
the new hole you have to fix. Unless you put a clause, unless it deteriorate, also you need to take. That's a different story. Okay, so now any condition you have to take. Now going on that, what I'm saying is, if the purchaser or vendor or purchaser usually asks you a specific question about the property, a certain condition, then you must answer accurately. And if they purchase the property based on your answer, then it's a problem. Now, weighing against something what we call caveat emptor. Caveat emptor means buyers beware.
Caveat emptor.
Caveat emptor.
Buyers be aware.
Okay. So this one is different. So let me weigh. Let me digest this so you don't misunderstand. So let's talk about this caveat emptor first. So let's say I'm selling this conference room now to you. All right? And I tell you, I'm selling you as is where is, please go and inspect it. So he inspected everything. Very good. So at the end of transaction, because he's selling as a bare unit, so we take out everything from here, table, whatnot, and we take out this screen. And suddenly at the back of the screen, there's a big hole there, or a big giant statue of Mr. Soma's face there, because they like you so much. Legendary.
Okay.
All right? And he said, no, got to remove. He said he want to put his face there. Okay. Now, my question then to the client is like this. Friend, did you not inspect the place? Yes. Were you not satisfied the condition? Yes. Did you tell specifically there must not be any hole or statue of Mr. Soma or whatever in this property? No, right? Then caveat emptor. Too bad. You did not check. So I give you an example. Sometimes you inspect a property. Agents also very clever. You check behind the cabinet. You open the cabinet behind, you move, leaking one hole there. You don't know, right? But you didn't check, too bad. Now, weighing against, like I give you an example, during another example, maybe during COVID time. You know, COVID time, only the men usually can go out and buy groceries and things like that. The men being men, I don't know lah. For me lah, you just go, looks good, buy. So you go and buy vegetable, look very good, inspect it, very nice, very good, right? And then go home, give back to your girlfriend, wife, whatever to cook. Then you open out inside full of worm. Can change, right? You cannot change, right? Unless got warranty. You know why? Because you inspected it, you're satisfied the condition, and you never tell the vegetable seller there must not be any worm there.
Oh, like that means every floor you must tell there must
correct.
be no worm.
Okay. Now, I weigh against the critical issue. Let's say you're selling this house and there's an illegal extension at the back. You know, those days, a lot of people extended it without permit, typical contractor lah. Those days, no permit, no nothing. But the vendor tells you, look, I extended my kitchen, but you know those days, we got no permit, I got no CF for the back one. I'm selling it as is where is, you want or not? Now, some of them say, I'm willing to buy this property, I'm going to do my own renovation, and anyway, this area, I won't name lah, some Taman 90 over property, also illegal extended, people know, famous Taman, I know the name. Some people may stay there, I know where, okay? So, I'm willing to take a chance. So, you're willing to take a chance, okay, no problem. Then we will put down in the LO, so the LO very important. You're selling it together, and then down there note, we do not have the CF or the plans for the extension, and you're aware, it's not, we don't have the permit for it. So you're buying it in that condition, you take your own chance, any penalty count or whatever, you pay. Now that is different. Now if that is the case, because I have disclosed to you, and you understood the risk as a business decision, you bought it anyway, then I'm not liable to you. In this one, because it's a critical thing, because it's an extension. The other story is, of course, there is business savvy lah. You can't tell everything, right? Unless you got a warranty, vegetable no warranty, right? Car got warranty, then okay.
So let me take this to what you said just now. You go and inspect. So what happens if there's termite? It's up in the ceiling and between the roof and the ceiling. You can't see, and generally public will not go up to inspect.
Correct.
So what happens if I know about it and then I don't disclose under the disclosure clause? Then what happens?
Well, for me, it's very simple. Like it or not, I do not think the rent will be liable because number one, you did not ask the agent whether you got this kind of issues. Okay? And I tell you, you go inspect it, I'm selling it to you as is where it is. You inspect it yourself. All right? That's why in overseas, I think Malaysia now they have all this special company to do inspection. So sometimes I think you see in the TV, last time what, House Hunter or something like that, the brothers, and they go in and they inspect and say, oh, this one asbestos, last time can, now cannot, this one. Oh, they actually got one report one, no? So they tell what can, what cannot, and things like that. So maybe we have to move a bit with time. I'm comparing to, I come across lately in Australia, like say student accommodation, those students go there, and the landlord, they go in and inspect, clean up the place, and then give you a report. No? So they give a report and tell you how is it like that. So if according to the report like that, and it's differing,
okay. But coming back to the question, I know about it. Should I, as an agent, disclose or not?
Of course, ethically you should disclose right? But if you're not obligated, it can come a gray area also. I mean, very frankly speaking, because sometimes, like if you are selling a house or old house, I'm not going to tell you. I may tell you generally, there's a bit of leakage here and there, but sometimes unless the person asks you specifically, where is the leakage? No, site okay lah. So wet proofing, another story, right? So that one, right? So you have to see very carefully. So this one also in a way educate the public. You're also educating the public. So you as a public then, maybe you should ask this question.
This I very clearly remember. I don't know. I'm a little bit mixed opinion of this. So somebody committed suicide 2 months earlier. And then now the house is for sale and I'm aware of it. And there's a Chinese buyer. And let me say Chinese buyer because they are very particular of feng shui. So should I disclose or not? And what happens is they come to find out about it after they have signed the sales and purchase agreement. Would there be an avenue for them to take legal action? I think that is the one. I know that there could be many variations to this, but I think you made a point that ethically should be disclosed.
Yes.
I mean, that's the point I wanted to stress.
But what I'm trying to say is actually for me, if I'm the agent, ethically and professionally, I will disclose. Reason is people are quite smart. They know this one illegal extension, right? This area got no problem. It's a good price. Anyway, I'm going to do a renovation. I do my own plan. It's okay. I take the chance. But you disclose to me, so okay, I accept it. So people will get more angry if some of them get angry. How come you never tell me this? Then the argument comes. Then it doesn't look good at you professionally also, right? So people already know. So for me, ethically, you should disclose, but in some extent, well, it's a business decision, right? I'm not obligated to tell you 100% of everything that happens there, unless you ask you.
Well, I may accept that argument that there's always the statement that states that if you think that information you have is going to have an effect on the decision making,
then maybe.
And I think we need to
disclose.
We have got a duty to explain that. Okay. Let's move on to the next question. Okay, this is very common in Penang and also in Penang and Johor. Dual agent. Let's put a new term: dual agency, meaning this agent collects from the buyer and then he also collects from the seller. 1%, 1%. Very common. Now, in our estate agency law, they very clearly stated you can only collect from one party. I think this is also in your legal practice. What what advice do you want to give as far as your role as an agent and having dual agency, collecting from two parties?
Of course, legally speaking, then I said, you cannot do that because it's a conflict of interest.
Okay.
Right? So if you are the representing the vendor, you should be trying to protect the interest of the vendor. If you're representing the purchaser, you should be trying to protect the interest of the purchaser. But you are a bit conflicted on this, you see. So because of that, then it have a lot of implication. Because if there is a dispute between them, you will be dragged inside. Obviously, you're going to be the witness because you close the whole deal for them. And then what are you going to do in court? You talk one way, you talk the other way, you expose yourself to liability from the other party to sue you. And they will say, I thought you're acting for me, here's the bill you paid for me. The other side, I thought you're acting for me, here's the bill you paid for me. So you're negligent in what you're doing. So that's why I don't know how Penang and Johor practice, but anyway, you stated the standards don't allow it, right? So I think it's clear cut. It's not allowed, right? So whether people like it or not, but that is the reality,
this is the reality. But
this is the reality.
Actually, as far as the practice is concerned, this is a very serious issue. It's a very serious issue, and of course, I'm puzzled as to why whoever is concerned are not taking the right direction towards stopping this, because it's actually very serious in Penang, and in fact, everyone there are doing this.
I think maybe sometimes, to be fair, maybe it was customary way of doing things long time ago. Some clients also like even you don't act for them or things like that. Instead that people belanja you makan, they sometimes I give you a bit of I don't know, like our gratitude. They give you some.
That's angpao. That's not a fee. Angpao, okay, you collect angpao and go.
So I think it came from there. So then the custom maybe in these two states that I don't know. I'm not in Penang, Johor. I don't want to say so. I'm not in Penang, Johor. I'll be banned from going there. But I'm just saying that
because as a practitioner, I think it's quite serious, and nobody is doing nothing about it. And education also not there. We have emphasized many times at MIA, please educate the public at large, because when I represent only one person, then I take care of your interests. So, but anyway, but legally.
But I got one question. I got one question with Soma. The standard say cannot. But what happens if both parties agree to this in black and white?
That one you don't ask me, like you have to answer. You are the lawyer.
I'm just asking. Right, so I don't know. It doesn't sound still conflict of interest.
Then there's always this thing that both parties have agreed, so why do you?
But when they fight, then that's the problem. You see, you must understand, when they fight, they're going to accuse all sorts of things.
That is why, I mean, if I may say, the practice in our country, we still have not matured to the point where the public and the agency know, like legal, you all charge disbursement, right? We also have got under the 7th schedule disbursement. We don't charge disbursement. Because if you go and ask also, they won't give. So the level of understanding and maturity in the practice also not. We're only 30, now we're only 30, I think 39 years since the law came into effect. Okay, so anyway, the standards and the rule says you cannot do that, okay? Next one, what common mistakes do agents make when they use standard agreements in a tenancy? Let's go to tenancy. They all type A, type B, type C. And then they go and say type A, then type B. You just take one copy and then do.
That is why I think that is why I said that agents, to me, should not draft tenancy agreement, because it looks standard. Like, remember the case I told you about, the 14 feet, 16 feet thing. Is that in your standard agreement? No. What happens you do industrial or warehouse? Those they need, I need you to conform with the bomber, fire sprinkler, not normal one, or the one on the shelf got one, or this I understand, here's on top. some people, or certain things you need to comply with certain regulation. Like after Putra Heights, what happened? Gas line blew up, right? So you are doing some sort of business down there and near all this sensitive area and things like that. So after the gas line thing also, I also now more aware, right? I was going around my area, I go to the MRT station, then I parked there, I was waiting there, and then I saw this yellow signboard down there. Don't park here, underneath got gas line. So I realized all the time there, the same one. No? So anytime, touch wood, something can happen, right? So what I'm trying to say is, when you copy and paste like a sale and purchase agreement, when you go to war, so to say, when you have a dispute, I think I quote you before I remember you said, words are very important. Okay? Just say like in legal, people don't legal. Will and shall is a different meaning. Will is not really binding in some circumstances, shall is binding. So I say lawyers draft the agreement in a strange way. So people don't understand these kind of things. So there is a lot of things in agreement when you cut and paste. 10 cases, 8 okay, but only take 1 or 2 to sing you.
Yeah.
So that is it's a big burden.
So there was a big hue and cry among all the agents. Even today, still, agents cannot stop complaining, unfortunately.
Okay.
Oh, why did the Bar Council say I cannot do tenancy? We have been doing this for all these years, and what is board doing about it? And the question also came to me when I was CEO of MIA. Can you just explain to them?
Okay.
I think this one is very important. Because they never realized that under the Solicitors Remuneration Act, which is equivalent to our 7 schedule, you already had the fees chargeable if you were to sell a property under certain conditions. Then now it has been formalized in another way. Just can you explain that? Did this exist before?
You're talking about which one? The tenancy one or the fee?
No, I'm talking about the fee.
The fee, okay. So the fee one, actually, you see, the agent shouldn't be so worried. What they meant is, if the client specifically asked them, because sometimes they have to do things, maybe they are trustees or executor or a corporate company, they have to do something, and the client specifically asked them, okay, you settle this agreement, you negotiate out for me. Actually, the word I negotiate out for you. So it's like a bit of more of a consultation, a wise negotiation on the part of a lawyer. Now, you see, lawyers in general, if you really think about it, under our ruling, we cannot just go out and advertise as we like.
Like agents.
Like agent, buy, sell is the best property or whatever. That is unbecoming of a lawyer. But we have specifically been appointed to do certain things by the client, then they're entitled to charge. So this clause is not new, been there for 18 years. So the same thing going back to the tenancy when they're making the hue and cry. I'm in practice for 30 years. Anybody can check, if I'm not mistaken, before the year 2000 plus, all lawyers do tenancy agreement. Where got agent do one? So the agent then takes some cut and paste I do. Then now you want to claim $200 and do way below the market. Cut and paste, I want to make some money. Okay, I ask the agent this. Are you trained? You know how to draft tenancy? The 4 elements I tell you, offer, acceptance, intention, legal consideration, half of you also don't know, with due respect. Don't talk about other things, right? So when we do, we also got a certain responsibility. So in reality, why the complaint? Because you cannot make money. So why should we not complain? Because we cannot make money also as professional. We are trained, right? So it's the same thing, right? So of course they say, then now we sell this. No. You don't see lawyers go out and advertise every day, sell the whole building. No, they don't. It's very specific cases. We are not allowed to, advertise or do something unbecoming of a lawyer.
I think
we have an act for it.
I think we all understand that. It's just that.
So it's not. So it's not a threat lah. You don't have to
It's not
worry.
a threat,
You will never
No,
replace
the
agents.
challenge we have
Yeah.
is we do not know what's happening all around.
Yeah.
So we become very emotional about all this. Okay. Okay. I want to move on to the next question. Time is catching up. Okay. What are the legal concerns surrounding e-signatures, digital contracts, and online communications in real estate transaction?
Actually, if you ask my opinion, most lawyers are not in favor of this. Okay. Number one, I think a number of years ago, our association also wrote to us. It said, look, you do it at your own risk. Because reason is when you do digital and online, number one, you cannot really see what document that person is signing. And there are so many pages. How I know they changed the page or anything like that? You say you claim you see a video. And is the person signing it under duress? Somebody put a gun on the head or whatever at the back, you cannot see. You cannot see what is happening. So there's always, when you do it this way, it's not very strong. And what more, this one you're talking about the agreement only. Then in conveyancing sale transaction, agents must remember it's not just sale and purchase agreement. They have to sign statutory declaration, transfer form, charge form, discharge of charge form, and under the land office regulation, they're supposed to sign before the High Commissioner or the lawyer or some in some circumstances the notary public in front. So you want us to put the signature and the chop there that we say you sign in front of me? And you know how many scams are there, right? So I have cases where we see people, stroke patient, this one, that one, the person is not coherent also. Sign, put thumbprint. Not sure, right? They go and check.
Digital signature.
Digital signature. But Malaysia do have an act. I think the Digital Signature Act and I think it's another act. I can't remember. But people they need a special cert like the post office. They courier to you. You sign on an electronic device. They have to give a cert or something. They pay. That is a different story. So you say convenient. It's convenient until you get cheated. Correct?
Yeah.
Then next day you complain. Why like that?
So basically what you're saying is that don't do e-signature.
Right now,
as far as SNP is concerned.
Yes, but maybe one day they have the technology where there's a suggestion, QR code or something to the effect and things like that. Someday identify that, okay. Right now, I think not yet. Don't encourage.
Okay. I wanted to ask this question because this is not really formalized in our country. What legal risks do agents face under what is being said as a fair housing laws? I don't want to sell to Indians, I don't want to sell to Malays and all that stuff. And what are the legal implications when we go and do this?
Oh, this one's a big can of worms. So I hope the new Residential Tenancy Act will address this. They are also talking about this. You see, when we have all these issues, then we have issue of clashing with Times Up, JMB and things like that. So which is which? The law. And then there's also a public policy law. So it's a bit untested, no? Unless people bring the case up to the very highest court. So I hope the Residential Tenancy Act will address this. I believe they're addressing it. So let's see what happens. There's a lot of implication there.
Yeah. I know this is very vague and
very vague.
Because everybody says I have a right to do what I want to do, and there's no public policy on this. You said it rightly. I think the Residential Tenancy Act should address this. So this issue can be addressed. Okay, I think time is up. I don't know, sometimes 1 hour finishes so fast, I got 10 questions. I think I only asked around 8 questions. So anyway, we are happy to have David Koch, a very experienced lawyer and a legal advisor for MIA, who does today, who shared his views very candidly, without favor, and expressed his legal opinion in a manner that he things right. So I want to appreciate your
Thank you.
opinion, David. Thank you very much. I think we have got a small souvenir to give you. I don't understand because of the camera, but I can I give you while we are seated down? Okay, here you are.
All right. Thank you. Thank you.
Hope you
Thank
enjoy
you.
whatever is in there.
Yes, yes,
Okay.
yes.
So with that, I want to thank all of you. There is a QR code after this. Please scan and you can send in your comments, and also go and visit Soma-san 007. I've got so many videos. There's 70 videos on real estate, 3-minute videos, TikTok and Instagram. Soma-san 007. Okay. With that, I want to thank you very much. I will see you next month, last Friday of next month. Thank you very much.
Thank you.